A lawyer has dual capacity. One, as the spokesperson of his client, and the other as the officer of the court. A lawyer must learn how to reconcile his duty towards his client with his duty towards the court. While acting as a lawyer for his client, a lawyer should not cross the permissible limit, otherwise he may even be held guilty of professional misconduct. To know more details, watch this video till the end. Kindly tell me whether you like the videos and postings of continuing legal education for lawyers. Unless I know that lawyers are finding them useful, I may lose my enthusiasm to make more videos and more postings. If you like them, please encourage me by pressing the like button or by making your comments. Hello my friends, my brothers and sisters in the legal profession. Welcome to the latest video under the series Continuing Legal Education for Lawyers. A lawyer has a duty towards his client, but at the same time, a lawyer has a duty towards the court. How do you reconcile the two conflicting duties? The client pays fees to a lawyer. The lawyer has to represent his client in a court of law. It is the duty of the lawyer to try his best for the success of his client in the case. He must argue to the best of his ability. But in order to win a case, can the lawyer adopt all means, fair or unfair? For example, can a lawyer help his client in manufacturing a forged document? Is there any limitation on the duty of a lawyer towards his client? We shall discuss this point in today's video. Undoubtedly, a lawyer has a duty towards his client, but at the same time, a lawyer must not forget his duty towards the court. A lawyer must not forget that he is an officer of the court. The legal profession is called honorable profession. Even the Chief Justice of India will call the junior most advocate in the country as the learned advocate. The duty of a lawyer towards the court does not mean that he should feel intimidated by the judge in the court, or that he should abandon his argument because of the dominating or sometimes threatening attitude of the judge. But you must know how to deal with such a situation tactfully and without annoying the judge any further. Sometimes the judge may not agree with your argument. He may say, your argument is bogus. He may say, you are wasting the time of the court by senseless argument. He may start shouting and order you to stop argument immediately. This is a very difficult situation, but a lawyer has to tackle the situation, and he can tackle it if he has learned the art of advocacy. If you have confidence that your argument is meritorious, you must persist with the argument, but in a very humble and respectful way. You may, in a very mild and respectful tone, submit before the judge. Your Lordship will kindly pardon me. I am the spokesman of my client. I am bound by my instructions. I will be failing in my duty if I do not argue this point before the court. This point, according to my limited knowledge, is in favor of my client. Even if your Lordship does not agree with me, I most humbly and respectfully beseech your Lordship to kindly record that I have made this submission. If your argument is not recorded, the appeal court may not allow you to raise the said point in appeal because there is no evidence to show that you have raised this point before the single judge. It is not professional misconduct to argue a point which may not be legally tenable, but a lawyer must not identify himself with his client. On facts, you should not argue a point which is not there in the pleadings. You should not argue a point which is contrary to the pleadings. You should not cite a provision of law which has been amended or repealed. You should not cite a case law which has been overruled. In any of these situations, if you exceed the permissible limit, you may be guilty of professional misconduct. You should not misbehave with the judge, even if he misbehaves with you. Your tone towards the judge must be very humble and respectful, though you are entitled to be firm in your submissions. Remember, a lawyer should not cross the point where his duty to the client ends and where he starts violating his duty to the court. Thank you.